back to you.
All right, thank you. And the protesting, it is growing. This is a massive protest in Philadelphia right now. You're taking a look at some live pictures. Now, the protesters say they wanted Officer Darren Wilson to have his day in court and felt there should be at least be charges in Michael Brown's death. The prosecutor chose to let a grand jury make that decision and is being criticized for going in that direction. Now, joining us to talk more about the grand jury process and what you may or may not understand about how it works is former prosecutor and current defense attorney Ed Booth from, and I want to make sure I get this right, Shuttleworth, Ruloff, Swain, Haddad, and Moorcock.
Yep, that's Haddad and Moorcock. You got it.
All right, thank you so much. My first question is it common for a prosecutor to go to a grand jury in a case like this?
Well, grand juries are common in any criminal case, but a lot of times it's sort of a pro forma process. This was a grand jury that involved a great deal of investigation, and that is somewhat unusual in state court.
How much guidance does a prosecutor usually give in a case like this? And in this particular case, I think he gave the jurors the evidence and said, okay, you decide what to do next. Don't you usually see more of a guiding process?
The typical role of the prosecutor or Commonwealth's attorney in Virginia is to sort of instruct the grand jury and ask for a particular indictment. But there's no requirement that they do that, no absolute requirement that they say, this is what you consider and this is what you should indict on. They can present options, and that appears to be what happened in this particular case.
Okay, they're looking for probable cause. Explain probable cause.
Well, probable cause is that sort of threshold burden in order to bring a criminal case. It's the same burden that a magistrate would look at when a warrant is brought. It's the same burden at a preliminary hearing in the Virginia Beach or any Virginia General District Court that a General District Court judge would hear on a felony. It's all the same burden. Basically, to simplify it, and this is an oversimplification, is it more likely than not that a crime did occur?
Okay. Now, the prosecutor, he talked a lot about conflicting witness testimony, a lot of how much does that matter in a grand jury decision or deliberation?
Well, it depends, because there's no hard and fast rule in terms of what a prosecutor needs to present to a grand jury. They can present only those things that they think are relevant, or they can present a whole wide range of witness testimony and evidence, and it appears that that's what happened in this case.
Because it's not unusual, obviously, for you to have conflicting witness testimony in trial. I mean,
absolutely. Now, grand juries are secret, and that's a bit different, but conflicting witness testimony in trial is exactly the sort of thing that a trial jury is tasked with deciding. In fact, that's one of the classic roles of a trial jury, to decide who's telling the truth.
Well, some of the criticism, some people are saying, is this appeared to be a trial in the dark, behind closed doors. Could you understand why that criticism is being said, or can you see where that comes from? Or?
Well, I haven't seen all the evidence or very much of it at all. I've seen the same coverage for the most part that everyone else has seen. So
yeah.
I can't comment on this particular case.
Right.
But I would just say in general that more information would seem to be a better process than less information. Usually we think more information leads to a better result, shines sunlight on the proceedings, and everyone will be able to reach an informed decision.
Okay, well, we'll continue to see how all this plays out, and I appreciate you taking some time.
Thank you very much for having me.
Yeah, thank you. Regina.
Janet.